Hello and welcome to this Legal Futures webinar entitled Contract Interpretation. My name is Keith Markham and I will be your presenter for this particular session today. Those are my details there. Let me just tell you a little bit about myself. I'm a company commercial lawyer, worked in private practice and in-house for many years, lots of issues around commercial contracts, hence why I'm delivering this session. Let's look at the agenda and I'll just go through one or two bits of background as to what we're going to be talking about in this session. So we're going to look at two things. We're going to look at the basic principles of contract interpretation as expressed in certain key cases. And we're going to look at the fact that typically there are two main approaches that we take: plain ordinary meaning and commercial common sense. And we'll see that over the years there has been a degree of debate among the courts as to which of those should have prominence. And that led to a series of fairly well-known Supreme Court cases that led to a case in 2017 called Wood and Capita. And essentially that then led to the establishment of a series of principles which have then been applied in more recent case law. So I'm going to take about the first quarter of this session to talk about those basic principles and how they work and how they should be applied. I will then go on to talk about recent case law, and we will see how they've been physically applied in different contexts. Those contexts include a lawyer's client care letter. They include exclusion clauses, notice provisions, material adverse effect provisions in a share purchase agreement, and also the context of a court order relating to provision of information to consumers. So a really wide range of cases that demonstrate how these things have then been put into practice. Right, the three key cases that sort of sit behind all of this then are on the next slide. Let's have a look at those. So here we are. We've got Rainy Sky and Kookmin from 2011. That is to do with an unfinished ship in a South Korean dockyard. And then a completely different world away, the next case, Arnold and Britton, is to do with leases over holiday chalets on the Gower Peninsula in Western Wales. Again, totally different world. And then finally, Wood and Capita is to do with an indemnity, or the interpretation of an indemnity in terms of a purchase of business, and there were various claims that followed in respect of mis-selling, breach of financial services regulation. Obviously the buyer wanted to rely on the indemnity to claim, and in the end the buyer was unable to do so because of the way the court chose to interpret that indemnity.